Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we have another guest reading, which we absolutely love. It is from Thomas Naciuk, who is currently a student at Ottawa, and he is going to read for us Vriend and Alberta. We want to thank him so much for reading for the podcast. It is absolutely amazing. Also, I don't think I can actually express how long this decision is and how much of a trooper Thomas was for reading the whole thing. It is a very long decision. We're going to break it up into parts for you. And it's such an important decision, but I fully admit it was too long for me to read. I was probably not going to read this one. So we definitely give Thomas all the props in the world for reading it. Do you know anything about this one, Zach?
I remember, again, it's one of the constitutional law, like ones that you take in 1L because you need to know it. Yeah. And I absolutely agree with that sentiment. Thank you so much, Thomas, for taking the time to read this because, again, Section 15 is already outside my wheelhouse, and then one that's this long is doubly so. But the through line I remember from this case is it basically allowed for Section 15 to include analogous grounds. And in this case, it was sexual orientation. Yeah,
it adds
and it was
sexual
included
orientation.
under the... Yeah. And I think that's great for the charter because it opens up Section 15 to be flexible and adaptable, which it needed to be instead of just being, written in stone, so to speak.
Yeah, definitely. No. It's a really interesting decision. It's totally worth the listen, even though it's definitely a little bit on the long side. And we want to say thanks again, Thomas. You did an amazing job. Also, if there's one thing this decision made very clear to me immediately while editing it, it was that my French pronunciation is horrific and has been horrific this entire time. So, perennial apology to Justice Gontier and Bastaroche because I have been saying those wrong since law school started, apparently. So bless Thomas forever for having actual correct Quebec pronunciation of words because that's not my wheelhouse. I was very embarrassed.
You get the chance to learn.
Yeah. It was very embarrassing how bad the French has been on my end. So we're going to leave it to Thomas, actually, who recorded a little bit of a voiceover himself as to why he chose the decision. So we're going to cut to him explaining why he chose it, and then it'll cut right to the decision. So take it away, Thomas.
This is the case of Vriend in Alberta. Vriend in Alberta is an interesting case for a number of reasons. First and foremost, it's a landmark case for LGBTQ rights, but it's also a case that illustrates the relationship between provincial human rights codes and the Charter. So in public law, it's often stressed, and for good reason, that the Charter does not apply to non-straight actors. But it's important to remember, as cases like Vriend show, that while there is truth to that statement, the Charter can be of indirect help in cases such as this. In Vriend, the Charter helped to expand the scope of the Alberta human rights legislation by reading in sexual orientation to the list of prohibited grounds. So the judgment of Chief Justice Lamer and Justices Gontier, Corey, McLaughlin, Iacobucci, and Bastaroche was delivered by Justices Corey and Iacobucci. In these joint reasons, Justice Corey has dealt with the issues pertaining to standing, the application of the Canadian Charter of Rights and Freedoms, and the breach of Section 15.1 of the Charter. Justice Iacobucci has discussed Section 1 of the Charter, the appropriate remedy, and the disposition. The reasons of Justice Corey. The Individual Rights Protection Act was first enacted in 1973. When the legislation was first introduced in 1972, the minister responsible commented upon and emphasized the nature and importance of the act, stating, "It is the commitment of this legislature that we regard the Individuals' Rights Protection Act in primacy to any other legislative enactment. We have committed ourselves to suggest that Alberta is not the place for partial rights or half freedoms, but that Alberta hopefully will become the place where each and every man and woman will be able to stand on his own 2 feet and be recognized as an individual and not as a member of a particular class." These are courageous words that give hope and comfort to members of every group that has suffered the wounds and indignities of discrimination. Has this laudable commitment been met? Factual background: history of the IRPA. The IRPA prohibits discrimination in a number of areas of public life and establishes the Human Rights Commission to deal with complaints of discrimination. The IRPA is first enacted prohibited discrimination in public notices, public accommodation, services or facilities, tenancy, employment practices, employment advertising, or trade union membership on the basis of race, religious beliefs, color, sex, marital status, age, ancestry, or place of origin. The Act has since been expanded to include other grounds in a series of amendments. These additions were apparently, at least in part, made in response to the enactment of the Charter and its judicial interpretation. In the most recent amendments, the name of the Act was changed to the Human Rights, Citizenship, and Multiculturalism Act. In 1990, the Act included the following list of prohibited grounds of discrimination: race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, and place of origin. At the present time, it also includes marital status, source of income, and family status. Despite repeated attempts for its inclusion, sexual orientation has never been included in the list of those groups protected from discrimination. In 1984 and again in 1992, the Alberta Human Rights Commission recommended amending the IRPA to include sexual orientation as a prohibited ground of discrimination. In an attempt to effect such an amendment, the opposition introduced several bills. However, not one went beyond first reading. Although at least one minister responsible for the administration of the IRPA supported the amendment, the correspondence with a number of cabinet members and members of the legislature makes it clear that the omission of sexual orientation from the IRPA was deliberate and not the result of an oversight. The reasons given for declining to take this action include the assertions that sexual orientation is a marginal ground, that human rights legislation is powerless to change public attitudes, and that there have only been a few cases of sexual orientation discrimination in employment brought to the attention of the minister. In 1992, the Human Rights Commission decided to investigate complaints of discrimination on the basis of sexual orientation. This decision was immediately vetoed by the government, and the minister directed the commission not to investigate the complaint. In 1993, the government appointed the Alberta Human Rights Review Panel to conduct a public review of the IRPA and the Human Rights Commission. When it had completed an extensive review, the panel issued its report entitled Equal in Dignity and Rights, a Review of Human Rights in Alberta, the Dignity Report. The report contained a number of recommendations, one of which was that sexual orientation be included as a prohibited ground of discrimination in the Act. In its response to the Dignity Report, the government stated that the recommendation regarding sexual orientation would be dealt with through this case. Vriend's dismissal from King's College and complaint to the Alberta Human Rights Commission. In December 1987, the appellant, Delwyn Vriend, was employed as a laboratory coordinator by King's College in Edmonton, Alberta. He was given a permanent full-time position in 1988. Throughout his term of employment, he received positive evaluations, salary increases, and promotions for his work performance. On February 20, 1990, in response to an inquiry by the president of the college, Vriend disclosed that he was a homosexual. In early January 1991, the Board of Governors of the college adopted a position statement on homosexuality, and shortly thereafter the president of the college requested Vriend's resignation. He declined to resign, and on January 28, 1991, Vriend's employment was terminated by the college. The sole reason given for his termination was his non-compliance with the policy of the college on homosexual practice. Vriend appealed the termination and applied for reinstatement but was refused. On June 11, 1991, Vriend attempted to file a complaint with the Alberta Human Rights Commission on the grounds that his employer discriminated against him because of his sexual orientation. On July 10, 1991, the Commission advised Vriend that he could not make a complaint under the IRPA because the Act did not include sexual orientation as a protected ground. Vriend, the Gay and Lesbian Awareness Society of Edmonton, GALA, the Gay and Lesbian Community Centre of Edmonton Society, and Dignity Canada Dignité for Gay Catholics and Supporters, collectively known as the Appellants, applied by originating notice of motion to the Court of Queen's Bench of Alberta for declaratory relief. The Appellants challenged the constitutionality of Sections 2 sub 1, 3, 4, 7 sub 1, and 8 sub 1 of the IRPA on the grounds that these sections contravene Section 15 sub 1 of the Charter because they do not include sexual orientation as a prohibited ground of discrimination. The standing of the appellants to bring the application was not challenged. The trial judge found that the omission of protection against discrimination on the basis of sexual orientation was an unjustified violation of Section 15 of the Charter, she ordered that the word sexual orientation be read into sections 2 sub 1, 3, 4, 7 sub 1, 8 sub 1, and 10 of the IRPA as a prohibited ground of discrimination. The majority of the Court of Appeal of Alberta granted the government's appeal. The appellants were granted leave to appeal to this court, and the respondents were granted leave to cross-appeal. An order of the Chief Justice stating constitutional questions was issued on February 10, 1997. Relevant statutory provisions. Since the time the appellant made his claim in 1992, the relevant statute was amended, the Individual Rights Protection Amendment Act. The Act is now known as the Human Rights, Citizenship, and Multiculturalism Act. In these reasons, however, we refer to the statute as amended as the Individual Rights Protection Act, or IRPA, since that is how the legislation was most often referred to by the parties on this appeal. For the sake of convenience, the provisions are set out below first as they existed at the time the action commenced, and then as they currently stand. Individual Rights Protection Act. Preamble. Whereas recognition of the inherent dignity and the equal and inalienable rights of all persons is the foundation of freedom, justice, and peace in the world, and whereas it is recognized in Alberta as a fundamental principle and as a matter of public policy that all persons are equal in dignity and rights without regard to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, or place of origin, and whereas it is fitting that this principle be affirmed by the Legislature of Alberta in an enactment whereby those rights of the individual may be protected. 2. Sub 1. No person shall publish or display before the public or cause to be published or displayed before the public any notice, sign, symbol, emblem, or other representation indicating discrimination or an intention to discriminate against any person or class of persons for any purpose because of their race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, or place of origin of that person or class of persons. 3. No person, directly or indirectly, alone or with another, by himself or by the interposition of another, shall a. Deny to any person or class of persons any accommodation, services, or facilities customarily available to the public, or b. Discriminate against any person or class of persons with respect to any accommodation, services, or facilities customarily available to the public, because of their race, religious beliefs, color, gender, physical disability, mental disability, ancestry, or place of origin of that person or class of persons, or of any other person or class of persons. Section 4. No person, directly or indirectly, alone or with another, by himself or by the interposition of another, shall a. Deny to any person or class of persons the right to occupy as a tenant any commercial unit or self-contained dwelling unit that is advertised or otherwise in any way represented as being available for occupancy by a tenant, or b. Discriminate against any person or class of persons with respect to any term or condition of the tenancy of any commercial unit or self-contained dwelling units, because of the race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, or place of origin of that person or class of persons, or of any person or class of persons. Section 7, Sub 1. No employer or person acting on behalf of an employer shall a. Refuse to employ or refuse to continue to employ any person, or b. Discriminate against any person with regard to employment or any term or condition of employment because of their race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, or place of origin of that person or of any other person. Subsection 2. Subsection 1, as it relates to age and marital status, does not affect the operation of any bona fide retirement or pension plan or the terms or conditions of any bona fide group or employee insurance plan. Subsection 3. Subsection 1 does not apply with respect to a refusal, limitation, specification, or preference based on a bona fide occupational requirement. Section 8, Sub 1. No person shall use or circulate any form of application for employment or publish any advertisement in connection with employment or prospective employment, or make any written or oral inquiry of an applicant a. that expresses either directly or indirectly any limitation, specification, or preference indicating discrimination on the basis of the race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, or place of origin of that person, or any person, or B, that requires an applicant to furnish any information concerning race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, or place of origin. Subsection 2. Subsection 1 does not apply with respect to a refusal, limitation, specification, or preference based on a bona fide occupational requirement. Section 10. No trade union, employers' organization, or occupational association shall A. exclude any person from membership in it, B. expel or suspend any member of it, or C. discriminate against any person or member because of the race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, or place of origin of that person or member. Section 11.1. A contravention of this act shall be deemed not to have occurred if the person who is alleged to have contravened the act shows that the alleged contravention was reasonable and justified in the circumstances. Section 16, sub 1. It is the function of the Commission, A, to forward the principle that every person is equal in dignity and rights without regard to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, or place of origin. B, to promote an understanding of, acceptance of, and compliance with this act. C, to research, develop, and conduct educational programs designed to eliminate discriminatory practices related to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, or place of origin, and D, to encourage and coordinate both public and private human rights programs and activities. Human Rights, Citizenship, Multiculturalism Act. Preamble. Whereas recognition of the inherent dignity and the equal and inalienable rights of all persons is the foundation of freedom, justice, and peace in the world, whereas it is recognized in Alberta as a fundamental principle and as a matter of public policy that all persons are equal in dignity, rights, and responsibilities without regard to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, or family status, whereas multiculturalism describes the diverse racial and cultural composition of Alberta society, and its importance is recognized in Alberta as a fundamental principle and as a matter of public policy, whereas it is recognized in Alberta as a fundamental principle and as a matter of public policy that all Albertans should share in an awareness and appreciation of the diverse racial and cultural composition of society, and that the richness of life in Alberta is enhanced by sharing that diversity, whereas it is fitting that these principles be affirmed by the legislature of Alberta in an enactment whereby those equality rights and that diversity may be protected. Section 2, sub 1. No person shall publish, issue, or display, or cause to be published, issued, or displayed before the public any statement, publication, notice, sign, symbol, emblem, or other representation that A. indicates discrimination or an intention to discriminate against a person or a class of persons, or B. is likely to expose a person or a class of persons to hatred or contempt because of the race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, or family status of that person or class of persons. Section 3. No person shall A. deny to any person or class of persons any goods, services, accommodations, or facilities that are customarily available to the public, or B. discriminate against any person or class of persons with respect to any goods, services, accommodation, or facilities that are customarily available to the public because of the race, religious beliefs, color, gender, physical disability, mental disability, ancestry, place of origin, marital status, source of income, or family status of that person or class of persons, or of any other person or class of persons. Section 4. No person shall A. deny to any person or class of persons the right to occupy as a tenant any commercial unit or self-contained dwelling unit that is advertised or otherwise in any way represented as being available for occupancy by a tenant, or B. discriminate against any person or class of persons with respect to any term or condition of the tenancy of any commercial unit or self-contained dwelling units because of the race, religious beliefs, color, gender, physical disability, mental disability, ancestry, place of origin, marital status, source of income, or family status of that person or class of persons, or of any other person or class of persons. Section 7, sub 1. No employer shall A. refuse to employ or refuse to continue to employ any person, or B. discriminate against any person with regard to employment or any term or condition of employment because of the race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, place of origin, family status, or source of income of that person or of any other person. Subsection 1, as it relates to age and marital status, does not affect the operation of any bona fide retirement or pension plan or the terms or conditions of any bona fide group or employee insurance plan. Subsection 3. Subsection 1 does not apply with respect to a refusal, limitation, specification, or preference based on a bona fide occupational requirement. Section 8, Sub 1. No person shall use or circulate any form of application for employment or publish any advertisement in connection with employment or prospective employment or make any written or oral inquiry of an applicant A that expresses either directly or indirectly any limitation, specification, or preference indicating discrimination on the basis of the race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, place of origin, family status, or source of income of any person, or B, that requires an applicant to furnish any information concerning race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, place of origin, family status, or source of income. Subsection 2. Subsection 1 does not apply with respect to a refusal, limitation, specification, or preference based on a bona fide occupational requirement. Section 10. No trade union, employers' organization, or occupational association shall A. exclude any person from membership in it, B. expel or suspend any member of it, or C. discriminate against any person or member because of the race, religious beliefs, color, gender, physical disability, mental disability, marital status, age, ancestry, place of origin, family status, or source of income of that person or member. Section 11.1. A contravention of this act shall be deemed not to have occurred if the person who is alleged to have contravened the act shows that the alleged contravention was reasonable and justified in the circumstances. Section 16, Sub 1. It is the function of the Commission, A, to forward the principle that all persons are equal in dignity, rights, and responsibilities without regard to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, or family status. B. To promote awareness and appreciation of and respect for the multicultural heritage of Albertan society. C. To promote an environment in which all Albertans can participate in and contribute to the cultural, social, economic, and political life of Alberta. D. To encourage all sectors of Alberta society to provide equality of opportunity. E. To research, develop, and conduct educational programs designed to eliminate discriminatory practices related to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, or family status. F. To promote an understanding of, acceptance of, and compliance with this act. G. To encourage and coordinate both public and private human rights programs and activities. And H. To advise the Minister on matters related to this act. Canadian Charter of Rights and Freedoms. Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Section 15, Sub 1. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination and, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Section 24, Sub 1. Anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Section 32, Sub 1. This charter applies A to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matters relating to the Yukon Territory and Northwest Territories, and B. to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. Section 52 of the Constitution Act 1982, Sub 1. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Decisions below. A. Alberta Court of Queen's Bench. The appellants applied to Justice Russell, as she then was, for an order declaring that sections 2 sub 1, 3, 4, and 7 sub 1 of the IRPA are inconsistent with section 15.1 of the Charter and infringes the appellant's rights as a result of the absence of sexual orientation from the list of prescribed grounds of discrimination. 2. That Vriend has the right to file a complaint under the IRPA alleging discrimination on the grounds of sexual orientation. And 3. That lesbians and gays have the right to the protections of the IRPA. At the outset, she found that the appellants had standing to challenge Section 10 as well as the other sections. Justice Russell was satisfied that the discrimination homosexuals suffer is so notorious that she could take judicial notice of it without evidence. She went on to consider whether homosexuals are a discrete and insular minority entitled to the protection under Section 15.1 of the Charter, and concluded that sexual orientation is properly considered an analogous ground under Section 15.1. This issue has since been resolved by the decision in Egan and Canada, which held that sexual orientation is an analogous ground. Next, Justice Russell considered whether the omission of sexual orientation under the IRPA constitutes discrimination under Section 15 of the Charter. She noted that it has been established that a discriminatory distinction in law can arise from either a commission or an omission. The Ontario Court of Appeal in Hague in Canada found that considering the larger social, political, and legal context, the omission of sexual orientation in the Canadian Human Rights Act constituted discrimination offending Section 15.1 of the Charter. Justice Russell agreed with this conclusion. She took note of the Obiter comments of Justice Leredibé in McKinney and University of Guelph, that the provinces could prohibit discrimination on some grounds but not others without violating the Charter. However, in her opinion, sexual orientation was related to sex or gender as a prohibited ground, and, while there is no obligation on the province to legislate to prohibit sexual discrimination, when it does so, it must provide an even-handed protection in a non-discriminatory manner or justify the exclusion. Justice Russell noted also that discrimination does not depend on a finding of invidious intent and concluded, regardless of whether there was any intent to discriminate, the effect of the decision to deny homosexuals recognition under the legislation is to reinforce negative stereotyping and prejudice, thereby perpetuating and implicitly condoning its occurrence. The facts in this case demonstrate that the legislation had a differential impact on the applicant Vriend. When his employment was terminated because of his personal characteristics, he was denied a legal remedy available to other similarly disadvantaged groups. That constitutes discrimination contrary to Section 15.1 of the Charter. Turning to the Section 1 justification test, Justice Russell held that since the Crown had failed to present any rationale to show that the violation was justified, it had failed to meet the requirements of Section 1. Even if the Crown were not required to show justification, she would have concluded that the violation was not justifiable. She found that the limitation was inconsistent with the objective and principles embodied in the preamble to the IRPA, and therefore there was no legislative objective of pressing and substantial concern justifying the limitation. Justice Russell further held that the denial of remedies provided by the IRPA was not rationally connected to the objective of protecting individual rights, and that since the omission was complete, it did not represent minimal impairment. Justice Russell reviewed the possible remedies under Section 52 of the Constitution Act 1982 that were set out in Schachter and Canada, and concluded that the only options in this case were striking down the legislation with or without a suspension of the declaration of invalidity or reading in. She decided that in this case, as in Hague, reading in was the most appropriate remedy. The omission was precisely defined and could be readily filled in by reading in. As well, reading in was preferable because it left the objective of the legislation intact, was less intrusive than striking down, and would not have so great a budgetary impact as to substantially change the legislative scheme. Justice Russell therefore ordered that the relevant sections of the Act be interpreted, applied, and administered as though they contain the words sexual orientation. The Alberta Court of Appeal. Justice of Appeal McClung. Justice McClung held that the first question to be resolved was whether the IRPA is answerable as it stands to the Charter. He was of the opinion that the omission of sexual orientation from the discrimination provisions of the IRPA does not amount to governmental action for the purpose of Section 32, Sub 1 of the Charter. In his view, the provisions of the Charter could not force the legislature to enact a provision dealing with a divisive issue if it has chosen not to do so. He concluded that the province had not exercised its authority with respect to a matter so as to come within Section 32, Sub 1b of the Charter. Justice McClung criticized the reasons of Justice Russell as proceeding from the proposition that human rights legislation must perfectly mirror the Charter. He noted the existence of some variation among provinces with respect to the prohibited grounds of discrimination included in rights legislation, and stated that provinces must have latitude in interpreting their powers under Section 92 of the Constitution Act 1867. To require all legislation to be consistent with the Charter would be a debacle for the autonomy of provincial lawmaking. Even if the omission by the legislature is subject to Charter scrutiny under Section 32 Sub 1, Justice McClung found no violations of Section 15 Sub 1. In his opinion, the IRPA neither drew any distinction between homosexuals and heterosexuals nor resulted in the imposition of burdens, limitations, or disadvantages, or the denial of benefits or opportunities with respect to homosexuals. He found that any inequality that may exist between homosexuals and heterosexuals exists independently of the IRPA. The statute is neutral and neither confers nor denies benefits to or withdraws protections from any Canadian. Although he found no violation of the Charter, Justice McClung considered that what the appropriate remedy would have been had there been a violation of the Charter. He disagreed with Justice Russell's decision to use the remedy of reading in and stated that the preferable response was to declare the Act unconstitutional and invalid, with a stay of the declaration to permit legislative, not judicial repair. Justice McClung suggested that reading up constitutes an intrusion of the judiciary into the legislative domain, which should be avoided whenever possible. Therefore, he would have, if necessary, declared the Act ultra vires, suspending this judgment for a period of 1 year to allow the legislature to address the defects in the IRPA. However, based on his reasons set out earlier, he allowed the appeal. Justice on Appeal O'Leary. Justice O'Leary agreed with Justice McClung that the appeal should be allowed, but for different reasons. He assumed that the Charter applied to the IRPA and rested his conclusion on a finding that the IRPA does not create a distinction based on sexual orientation. In his opinion, therefore, there was no violation of Section 15 Sub 1. Justice O'Leary looked at the initial hurdle of the Section 15 Sub 1 analysis, which is to show that there are one or more provisions in the legislation which create expressly or by adverse effect a distinction between individuals which is contrary to Section 15 Sub 1. This state of affairs is to be distinguished from one in which these social circumstances exist independently of the provision. According to Justice O'Leary, the IRPA's silence with respect to sexual orientation means that the Act makes no distinction between individuals on the basis of sexual orientation. He found that the IRPA only distinguishes between the specified prohibited grounds of discrimination and the various potential grounds, including sexual orientation, which could be included but are not, and that this cannot be called a distinction on the basis of sexual orientation. As a result, Justice O'Leary would allow the appeal and set aside the declaration made by the trial judge on the basis that the IRPA does not create a distinction that offends Section 15 Sub 1. Justice on Appeal Hunt, dissenting. Justice Hunt partially agreed with the decision of Justice Russell, finding that Sections 7 Sub 1, 8 Sub 1, and 10 of the IRPA violate Section 15 Sub 1 of the Charter and are not saved by Section 1, but she found that reading in was not the appropriate remedy. With respect to Section 15 violation, she reached the same conclusion as Justice Russell, but on slightly different reasoning, in part due to the decisions in Egan, Miron and Trudel, and Thibodeau and Canada, which had by then been released. At the outset, Justice Hunt dismissed the argument that Section 15 Sub 1 was not applicable in this case because it concerned private activity. It is an act of the legislature which is being attacked in this case, not private activity, and provincial legislation is clearly subject to the Charter. Justice Hunt disagreed with Justice Russell's characterization of discrimination on the basis of sexual orientation as being directly associated with discrimination on the basis of gender, and her analogy between this case and the cases of Reed Blaney and Ontario Hockey Association and McKinney, mentioned earlier, where protection was offered from discrimination on the basis of gender and age, but only in a limited way. She went on to examine the context and purpose of the law, as well as its impact upon those to whom it applies and those whom it excludes. She found that the IRPA is a law that is dedicated to achieving equal treatment for all citizens in Alberta. The context is one of the existing discrimination against a group which has suffered from historical disadvantage. Justice Hunt concluded that given these considerations and the context here, it is my opinion that the failure to extend protection to homosexuals under the IRPA can be seen as a form of government action that is tantamount to approving ongoing discrimination against homosexuals. Thus, in this case, legislative silence results in the drawing of a distinction. Therefore, Justice Hunt would have concluded that there was a distinction drawn sufficient to find a potential violation of Section 15 sub 1. In her opinion, it was then easy to conclude that this distinction resulted in homosexuals as a group being denied equal benefit and protection of the law, since they are denied access to the IRPA's protection and enforcement process. The next question was whether this distinction results in discrimination. Justice Hunt found that according to any of the approaches set out in Egan, discrimination could be found in this case. The denial of the equal protection and benefit of the law here is purely on the basis of sexual orientation, not merit or need, and reinforces the stereotype that homosexuals are less deserving of protection and therefore less worthy of value as human beings. Even taking into account the relevance of the distinction to the goals of the legislation, it is impossible to see how a statute based upon notions of the inherent dignity of all can have as a relevant legislative goal the unequal treatment of some members of society on the grounds of their membership in a group. This is a case in which the functional values underlying the omission are themselves discriminatory. Turning to Section 1 of the Charter, Justice Hunt noted that the Crown had not presented any evidence concerning justification under Section 1. Justice Hunt found that the material in the Crown's factum inadequate to conduct a Section 1 analysis, and thought that the paucity of the Crown's case on this matter would, of itself, support the conclusion of the trial judge that Section 1 justification had not been established. In any case, the omission could not satisfy the Oakes test for justification. Although she found an unjustifiable violation of Section 15 sub 1, Justice Hunt disagreed with the trial judge's choice of remedy. Justice Hunt was of the opinion that the remedy should be limited to the situation presented in this case, and that the provisions most closely related to it, that is, discrimination in employment, employment notices, and union membership, respectively. While there were some arguments here in favor of reading in, Justice Hunt was concerned whether reading in could be accomplished with sufficient precision, and about the possible impact of reading in on Section 7 sub 2 of the IRPA, which concerns retirement, pension, and insurance plans. Justice Hunt therefore concluded that the preferable remedy was to declare invalid Sections 7 sub 1, 8 sub 1, and 10 of the IRPA to the extent of their inconsistency with the Charter. Since an immediate declaration of invalidity would remove protection from everyone, contrary to the Charter's objectives, she would have suspended the declaration of an invalidity for a period of 1 year to allow the legislature time to bring the IRPA into line with the Charter. Alberta Court of Appeal supplementary reasons regarding costs. Justice O'Leary, with Justice McClung concurring, held that the circumstances in this case did not justify deviating from the customary rule of awarding costs to the successful party. Justice O'Leary acknowledged that the court had discretion in awarding costs and that the public interest character of litigation could be used as an argument for depriving the successful litigation of costs. He noted, however, that such arguments had been rejected in some cases. He therefore awarded the costs of the appeal on a party-by-party basis to the Crown, to include all reasonable disbursements except traveling and accommodation expenses, and including a fee in respect of its written submissions on the issue of costs and a second counsel fee. Justice Hunt dissented. She noted that the decision of the Court of Appeal had involved a 2-1 split with 3 separate reasons for judgment, and that an important and novel point of law was at issue. She also noted several cases in which the courts have made no costs award, including Dickinson and University of Alberta, BR and Children's Aid Society of Metropolitan Toronto, and Canadian Council of Churches in Canada, Minister of Employment and Immigration. Justice Hunt agreed that governments should not be assumed to have limitless resources and that the relative resources of the parties is not the critical factor. She also noted, however, that there is no program in Alberta to subsidize the pursuit of important charter litigation as there is at the federal level. This case was not only novel, but also one that could be truly described as a test case, where the impact of the rule on the parties is of secondary importance to the settlement of the rule itself. Justice Hunt was of the opinion that there was a heavy public interest component to the legal question. As a result of all of these factors, Justice Hunt concluded that she would have awarded costs against the respondents, appellants in the Court of Appeal, notwithstanding their success on the appeal. However, since the appellants, respondents in the Court of Appeal, in this case merely sought a no-cost order, that this order should have been made. Issues. The constitutional questions which have been stated by this court are: Question 1. Do A. Decisions not to include sexual orientation, or B. The non-inclusion of sexual orientation as a prohibited ground of discrimination in the preamble and sections 2 sub 1, 3, 4, 7 sub 1, 8 sub 1, 10, and 16 sub 1 of the Individual Rights Protection Act, now called the Human Rights, Citizenship, and Multiculturalism Act, infringe or deny the rights guaranteed by Section 15 sub 1 of the Canadian Charter of Rights and Freedoms? Question 2. If the answer to question 1 is yes, is the infringement or denial demonstrably justified as a reasonable limit pursuant to Section 1 of the Canadian Charter of Rights and Freedoms? The parties have also raised issues with respect to standing, the application of the Charter, and the appropriate remedy. Analysis. Standing. The appellants seek to challenge the preamble and sections 2 sub 1, 3, 4, 7 sub 1, 8 sub 1, 10, and 16 sub 1 of the IRPA. The respondents on this appeal submitted that the appellants should have standing to challenge only the sections of the IRPA relating to employment, namely sections 7 sub 1, 8 sub 1, and 10, since the factual background of the case involves discrimination in employment. The Attorney General of Canada goes even further by arguing that the only provision at issue in this case is section 7 sub 1, which specifically addresses discrimination in employment practices. The originating notice of motion filed by the appellants in the Court of Queen's Bench referred to sections 2 sub 1, 3, 4, and 7 sub 1 of the IRPA. At trial, they were allowed to amend their application to include section 10, which had been omitted as the result of an oversight. In making this decision, Justice Russell applied the test for public interest standing from Canadian Council of Churches and concluded that the appellants had standing to challenge section 10 as well. The way in which she articulated this conclusion implies that the appellants also had standing to challenge the other sections of the Act referred to in the originating notice. There is no reason to disagree with this assessment. In Canadian Council of Churches, it was stated that 3 aspects should be considered. First, is there a serious issue raised as to the invalidity of legislation in question? Second, has it been established that the plaintiff is directly affected by the legislation? Or, if not, does the plaintiff have a genuine interest in its validity? Third, is there another reasonable and effective way to bring the issue before the court? It is my opinion that these criteria are met with respect to all of the provisions named by the appellants, being the preamble and sections 2 sub 1, 3, 4, 7 sub 1, 8 sub 1, 10, and 16 sub 1. A serious issue as to constitutional validity is raised with respect to all of these provisions. The issue is substantially the same for all of the provisions from which sexual orientation is excluded as a prohibited ground of discrimination. There is nothing in particular about section 7 sub 1 or section 7 sub 1, 8 sub 1, and 10 that makes their validity any more questionable than any of the other provisions dealing with discrimination. The respondents argue that there is no serious issue as to the constitutional validity of the preamble and section 16, which sets out the functions of the Ontario Human Rights Commission, because those provisions do not confer any specific benefit or protection. Although neither of those 2 provisions directly confer a benefit or a protection, arguably they do so indirectly. An omission from those provisions could well have at least some of the same effects as the omission of these rights from the other sections, and therefore raises a serious issue of constitutional validity. Further, Vriend and the other appellants have a genuine and valid interest in all of the provisions they seek to challenge. Both Vriend as an individual and the appellant organizations have a direct interest in the exclusion of sexual orientation from all forms of discrimination. What is at issue here is the exclusion of sexual orientation as a protected ground from the IRPA and its procedures for the protection of human rights. This is not a case about employment discrimination as distinct from any other form of discrimination that occurs within the private sphere and is covered by provincial human rights legislation. Insofar as the particular situation and factual background of the appellant Vriend is relevant to establishing the issues on appeal, it is the denial of access to the complaint procedure of the Alberta Human Rights Commission that is the essential element of this case, and not his dismissal from King's College. The particular issues relating to his loss of employment would be for the Human Rights Commission to resolve and do not form part of this appeal. It must also be remembered that Vriend is only one of 4 appellants. The other 3 are organizations which are generally concerned with the rights of gays and lesbians and their protection from discrimination in all areas of their lives. There is nothing to restrict their involvement in this appeal to matters of employment. With respect to the third criterion, the only other way the issue could be brought before the court with respect to the other sections would be to wait until someone is discriminated against on the ground of sexual orientation in housing, goods and services, etc., and challenge the validity of the provision in each appropriate case. This would not only be wasteful of judicial resources, but also unfair, in that it would impose burdens of delay, cost, and personal vulnerability to discrimination for the individuals involved in these eventual cases. This cannot be a satisfactory result. As well, it is important to recall that all of the provisions are very similar and do not depend on any particular factual context in order to resolve their constitutional status. The fact that homosexuals have suffered discrimination in all aspects of their lives was accepted in Egan. It follows that there is really no need to adduce additional evidence regarding the provisions concerned with discrimination in areas other than employment. Therefore, the appellants have standing to challenge the validity of all of the provisions named in the constitutional questions, namely the preamble and sections 2 sub 1, 3, 4, 7 sub 1, 8 sub 1, 10, and 16 sub 1 of the IRPA. Application of the Charter. Does Section 32 of the Charter prohibit consideration of a Section 15 violation when that issue arises from a legislative omission? The respondents, appellants on the cross-appeal, argue on their cross-appeal that because this case concerns a legislative omission, Section 15 of the Charter should not apply pursuant to Section 32. This submission cannot be accepted. This issue is resolved simply by determining whether the subject of the challenge in this case is one to which the Charter applies pursuant to Section 32. Questions relating to the nature of the legislature's decision, its effect, and whether it is neutral are relevant instead to the Section 15 analysis. The threshold test demands only that there is some matter within the authority of the legislature which is the proper subject of a Charter analysis. At this preliminary stage, no judgment should be made as to the nature or validity of this matter or subject. Undue emphasis should not be placed on the threshold test, since this could result in effectively and unnecessarily removing significant matters from a full Charter analysis. Further confusion results when arguments concerning the respective roles of the legislature and the judiciary are introduced into the Section 32 analysis. These arguments put forward the position that courts must defer to a decision of the legislature not to enact a particular provision, and that the scope of Charter review should be restricted so that such decisions will be unchallenged. I cannot accept this position. Apart from the very problematic distinction it draws between legislative action and inaction, this argument seeks to substantially alter the nature of the considerations of legislative deference in Charter analysis. The deference very properly due to the choices made by the legislature will be taken into account in deciding whether a limit is justified under Section 1, and again in determining the appropriate remedy for a Charter breach. My colleague, Justice Iacobucci, deals with these considerations at greater length more fully in his reasons. The notion of judicial deference to legislative choices should not, however, be used to completely immunize certain kinds of legislative decisions from Charter scrutiny. Justice McClung in the Alberta Court of Appeal criticized the application of the Charter to a legislative omission as an encroachment by the courts on legislative autonomy. He objected to what he saw as judges dictating provincial legislation under the pretext of constitutional scrutiny. In his view, a choice by the legislature not to legislate with respect to a particular matter within its jurisdiction, especially a controversial one, should not be open to review by the judiciary. When they choose silence, provincial legislatures need not march to the Charter drum. In a constitutional sense, they need not march at all. The Canadian Charter of Rights and Freedoms was not adopted by the provinces to promote the federal extraction of subsidiary legislation from them, but only to police it once it is proclaimed, if it is proclaimed. There are several answers to this position. The first in that, in this case, the constitutional challenge concerns the IRPA, legislation that has been proclaimed. The fact that it is the under-inclusiveness of the Act which is at issue does not alter the fact that it is the legislative act which is the subject of Charter scrutiny in this case. Further, the language of Section 32 does not limit the application of the Charter merely to positive actions encroaching on rights or the excessive exercise of authority, as Justice McClung seems to suggest. These issues will be dealt with shortly, yet at this point it must be observed that Justice McClung's reasons also imply a more fundamental challenge to the role of the courts under the Charter, which also must be answered. This issue is addressed in the reasons of my colleague Justice Yakabuchi below, and that the discussion need not be repeated here. However, at the present stage of the analysis, it may be useful to clarify the role of the judiciary in responding to a legislative omission which is challenged under the Charter. It is suggested that this appeal represents a contest between the power of democratically elected legislatures to pass the laws they see fit and the power of the courts to disallow those laws, or to dictate that certain matters be included in those laws. To put the issue in this way is misleading and erroneous. Quite simply, it is not the courts which limit the legislatures. Rather, it is the Constitution, which must be interpreted by the courts, that limit the legislatures. This is necessarily true of all constitutional democracies. Citizens must have the right to challenge laws which they consider to be beyond the power of the legislatures. When such a challenge is properly made, the courts must, pursuant to their constitutional duty, rule on the challenge. It is said, however, that this case is different because the challenge centers on the legislature's failure to extend the protection of a law to a particular group of people. This position assumes that it is only a positive act rather than an omission which may be scrutinized under the Charter. In my view, for the reasons that will follow, there is no legal basis for drawing such a distinction. In this, as in other cases, the courts have a duty to determine whether the challenge is justified. It is not a question, as Justice McClung suggested, of the courts imposing their view of ideal legislation, but rather of determining whether the challenged legislative act or omission is constitutional or not. Justice McClung's position that judicial interference is inappropriate in this case is based on the assumption that the legislature's silence in this case is neutral. Yet questions which raise the issue of neutrality can only be dealt with in the context of the Section 15 analysis itself. Unless that analysis is undertaken, it is impossible to say whether the omission is indeed neutral or not. Neutrality cannot be assumed. To do so would remove the omission from the scope of judicial scrutiny under the Charter. The appellants have challenged the law on the ground that it violates the Constitution of Canada, and the courts must hear and consider that challenge. If, as challenged, the IRPA excludes some people from receiving benefits and protections it confers on others in a way that contravenes the equality guarantees in the Charter, then the courts have no choice but to say so. To do less would be to undermine the Constitution and the rule of law. Let us now consider the substance of the respondents' position on this issue. The respondents contend that a deliberate choice not to legislate should not be considered government action, and thus does not attract Charter scrutiny. This submission should not be accepted. They assert that there must be some exercise of Section 32 authority to bring the decision of the legislature within the purview of the Charter. Yet there is nothing either in the text of Section 32 or in the jurisprudence concerned with the application of the Charter which requires such a narrow view of the Charter's application. The relevant subsection, Section 32, sub 1b, states that the Charter applies to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. There is nothing in that wording to suggest that a positive act encroaching on rights is required. Rather, the subsection speaks only to matters within the authority of the legislature. Diane Potier has correctly observed that Section 32 is worded broadly enough to cover positive obligations on a legislature such that the Charter will be engaged, even if the legislature refuses to exercise its authority. The application of the Charter is not restricted to situations where the government actively encroaches on rights. The IRPA is being challenged as unconstitutional because of its failure to protect Charter rights, that is to say, under-inclusiveness. The mere fact that the challenged aspect of the Act is its under-inclusiveness should not necessarily render the Charter inapplicable. If an omission were not subject to the Charter, under-inclusive legislation which was worded in such a way as to simply omit one class rather than to explicitly exclude it would be immune from Charter challenge. If this position was accepted, the form rather than the substance of the legislation would determine whether it was open to challenge. This result would be illogical and, more importantly, unfair. Therefore, where, as here, the challenge concerns an act of the legislature that is under-inclusive as a result of an omission, Section 32 should not be interpreted as precluding the application of the Charter. It might also be possible to say in this case that the deliberate decision to omit sexual orientation from the provisions of the IRPA is an act of the legislature to which the Charter should apply. This argument is strengthened and given a sense of urgency by the considered and specific positive actions taken by the government to ensure that those discriminated against on the grounds of sexual orientation were excluded from the protective procedures of the Human Rights Commission. However, it is not necessary to rely on this position in order to find that the Charter is inapplicable. It is also unnecessary to consider whether a government could properly be subjected to a challenge under Section 15 of the Charter for failing to act at all, in contrast to a case such as this, where it acted in an under-inclusive manner. It has been held that certain provisions of the Charter, for example those dealing with minority language rights, being Section 23, do indeed require a government to take positive actions to ensure that those rights are respected. It has not yet been necessary to decide in other contexts whether the Charter might impose positive obligations on the legislatures or on Parliament, such that a failure to legislate could be challenged under the Charter. Nonetheless, the possibility has been considered and left open in some cases. For example, in McKinney, Justice Wilson made a comment in Obiter that it is not self-evident to me that the government could not be found to be in breach of the Charter for failing to act. In Hague, in Canada, Justice Leredibé, speaking for the majority and relying on comments made by Chief Justice Dixon in a reference re Public Service Employment Relations Act, suggested that in some situations the Charter might impose affirmative duties on the government to take positive action. Finally, in Eldridge and British Columbia, Attorney General, Justice Laforêt, speaking for the court, left open the question whether the Charter might oblige the state to take positive actions. However, it is neither necessary nor appropriate to consider that broad issue in this case. Application of the Charter to private activity. The respondents further argue that the effect of applying the Charter to the IRPA would be to regulate private activity. Since it has been held that the Charter does not apply to private activity, as in Dolphin Delivery and Tremblay and McKinney, among others, it is said that the application of the Charter in this case would not be appropriate. This argument cannot be accepted. The application of the Charter to the IRPA does not amount to applying it to private activity. It is true that the IRPA itself targets private activity and as a result will have an effect upon that activity, yet it does not follow that this indirect effect should remove the IRPA from the purview of the Charter. It would lead to an unacceptable result if any legislation that regulated private activity would, for that reason alone, be immune from Charter scrutiny. The respondent's submission has failed to distinguish between private activity and laws that regulate private activity. The former is not subject to the Charter, where the latter obviously is. It is the latter which is at issue in this appeal. This case cannot be compared to McKinney, where Justice Laforêt, speaking for the majority, stated that there is no question that, the Human Rights Code being a law, the Charter applies to it. Those words are applicable to the situation presented in this case. The constitutional challenge here concerns the IRPA, an act of the Alberta legislature. It does not concern the acts of King's College or any other private entity or person. This, I think, is sufficient to dispose of the respondent's submissions on this point. Section 15, Sub 1. Approach to Section 15, Sub 1. The rights enshrined in Section 15, Sub 1 of the Charter are fundamental to Canada. They reflect the fondest dreams, the highest hopes, and finest aspirations of Canadian society. When universal suffrage was granted, it recognized to some extent the importance of the individual. Canada, by the broad scope and fundamental fairness of the provisions of Section 15, Sub 1, has taken a step further in the recognition of the fundamental importance and the innate dignity of the individual. That it has done so is not only praiseworthy, but essential to achieving the magnificent goal of equal dignity for all. It is the means of giving Canadians a sense of pride. In order to achieve equality, the intrinsic worthiness and importance of every individual must be recognized, regardless of the age, sex, color, origins, or other characteristics of the person. This in turn should lead to a sense of dignity and worthiness for every Canadian and the greatest possible pride and appreciation in being a part of a great nation. The concept and principle of equality is almost intuitively understood and cherished by all. It is easy to praise these concepts as providing the foundation for a just society which permits every individual to live in dignity and in harmony with all. The difficulty lies in giving real effect to equality. Difficult as the goal of equality may be, it is worth the arduous struggle to attain. It is only when equality is a reality that fraternity and harmony will be achieved. It is then that all individuals will truly live in dignity. It is easy to say that everyone who is just like us is entitled to equality. Everyone finds it more difficult to say that those who are different from us in some way should have the same equality rights that we enjoy. Yet so soon as we say any enumerated or analogous group is less deserving and unworthy of equal protection and benefit of the law, all minorities and all of Canadian society are demeaned. It is deceptively simple and so devastatingly injurious to say that those who are handicapped or of a different race or religion or color or sexual orientation are less worthy. Yet if any enumerated or analogous group is denied the equality provided by Section 15, then the equality of every other minority group is threatened. That equality is guaranteed by our Constitution. If equality rights for minorities had been recognized, the all too frequent tragedies of history might have been avoided. It can never be forgotten that discrimination is the antithesis of equality and that it is the recognition of equality which will foster the dignity of every individual. How then should the analysis of Section 15 proceed? In Egan, the two-step approach taken in Andrews and Law Society of British Columbia and the Queen and Turpin was summarized and described in this way. The first step is to determine whether, due to a distinction created by the question law, a claimant's right to equality before the law, equality under the law, equal protection of the law, or equal benefit of the law has been denied. During this first step, the inquiry should focus upon whether the challenged law has drawn a distinction between the claimant and others based on personal characteristics. Not every distinction created by legislation gives rise to discrimination. Therefore, the second step must be to determine whether the distinction created by the law results in discrimination. In order to make this determination, it is necessary to consider first whether the equality right was denied on the basis of a personal characteristic which is enumerated in Section 15 sub 1, or which is analogous to those enumerated, and second, whether that distinction has the effect on the claimant of imposing a burden, obligation, or disadvantage not imposed upon others, or of withholding or limiting access to benefits or disadvantages which are available to others. A similar approach was taken by Justice McLaughlin in Mirren. The analysis under Section 15.1 involves two steps. First, the claimant must show a denial of equal protection or equal benefit of the law as compared with some other person. Second, the claimant must show that the denial constitutes discrimination. At this second stage, in order for discrimination to be made out, the claimant must show that the denial rests on one of the grounds enumerated in Section 15 sub 1, or an analogous ground that the unequal treatment is based on the stereotypical application of presumed group or personal characteristics. In Mirren and Egan, Chief Justice Lamarre and Justices Laforêt, Gontier, and Major articulated a qualification which, as described in Benner and Canada's Secretary of State, focuses on the relevancy of a distinction to the purpose of the legislation where that purpose is not itself discriminatory and recognizes that certain distinctions are outside of the scope of Section 15. This approach is, to a certain extent, compatible with the notion that discrimination commonly involves the attribution of stereotypical characteristics to members of an enumerated or analogous group. It has subsequently been explained, however, that it is not only through the stereotypical application of presumed group or personal characteristics that discrimination can occur, although this may be common to many instances of discrimination. As stated by Justice Sapinka in Eaton and Brant County Board of Education, the purpose of Section 15 sub 1 of the Charter is not only to prevent discrimination by the attribution of stereotypical characteristics to individuals, but also to ameliorate the position of groups within Canadian society who have suffered disadvantage by exclusion from mainstream society, as has been the case with disabled persons. The principal object of certain of the prohibited grounds is the elimination of discrimination by the attribution of untrue characteristics based on stereotypical attitudes relating to immutable conditions such as race or sex. The other equally important objective seeks to take into account the true characteristics of this group, which act as headwinds to the enjoyments of society's benefits and to accommodate them. These approaches to the analysis of Section 15 sub 1 have been summarized and adopted in subsequent cases, for example, Eaton, Benner, and most recently in Eldridge. In Eldridge, Justice Laforêt, writing for the unanimous court, stated, "While this court has not adopted a uniform approach to Section 15 sub 1, there is broad agreement on the general analytic framework. See Eaton and Brant County Board of Education, Mirren, and Egan. A person claiming a violation of Section 15 sub 1 must first establish that because of a distinction drawn between the claimant and others, the claimant has been denied equal protection or equal benefit of the law. Secondly, the claimant must show that the denial constitutes discrimination on the basis of one of the enumerated grounds listed in Section 15 sub 1, or one analogous thereto. In this case, as in Eaton, Benner, and Eldridge, any differences that may exist in the approach to Section 15 sub 1 would not affect the result, and it is therefore not necessary to address those differences. The essential requirements of all these cases will be satisfied by inquiring first whether there is a distinction which results in the denial of equality before or under the law, or of equal protection or benefit of the law, and second, whether this denial constitutes discrimination on the basis of an enumerated ground or analogous ground. The IRPA creates a distinction between the claimant and others based on a personal characteristic, and because of that distinction, it denies the claimant equal protection or equal benefit of the law. Does the IRPA create a distinction? The respondents have argued that because the IRPA merely omits any reference to sexual orientation, this neutral silence cannot be understood as creating a distinction. They contend that the IRPA extends full protection on the grounds contained within it to heterosexuals and homosexuals alike, and therefore there is no distinction and hence no discrimination. It is the respondent's position that if any distinction is made on the basis of sexual orientation, that distinction exists because it is present in society and not because of the IRPA. These arguments cannot be accepted. They are based on that thin and impoverished notion of equality referred to in Eldridge. It has been repeatedly held that identical treatment will not always constitute equal treatment, as in Andrews. It is also clear that the way in which an exclusion is worded should not disguise the nature of the exclusion so as to allow differently drafted exclusions to be treated differently. For example, Schachter discussed this point in the context of remedies and quoted Nodal and British Columbia Medical Services Commission. Where the state makes a distinction between two classes of individuals, A and B, the manner in which the legislative provision or law is drafted is irrelevant for constitutional purposes. That is, it is immaterial whether the subject law states either 1, that A benefits, or 2, everyone benefits except B. In both cases, the impact upon the individual within Group B is the same. The respondents concede that if homosexuals were excluded altogether from the protection of the IRPA, in the sense that they were not protected from discrimination on any grounds, this would be discriminatory. Clearly, that would be discrimination of the most egregious kind. It is true that gay and lesbian individuals are not entirely excluded from the protection of the IRPA. They can claim protection on some grounds, yet that certainly does not mean that there is no discrimination present. For example, the fact that a lesbian and a heterosexual woman are both entitled to bring a complaint of discrimination on the basis of gender does not mean that they have equal protection under the Act. Lesbian and gay individuals are still denied protection under the ground that may be the most significant for them, discrimination on the basis of sexual orientation. The respondents also seek to distinguish this case from McKinney and Blaney. In Blaney, the Ontario human rights legislation prohibited discrimination on the basis of gender, but expressly allowed it in athletic organizations. Similarly, in McKinney, the impugned legislation prohibited discrimination on the basis of age, but in circumstances of employment, age was defined as 18 to 65, thereby depriving elderly workers of a benefit under the statute on the basis of their age. In both cases, the legislation was found to violate Section 15 sub 1. The respondents suggest that because the government in those cases had decided to provide protection, it had to do so in a non-discriminatory manner, but that the present case is distinguishable because the IRPA remains silent with respect to sexual orientation. The fact that the legislation explicitly places limits on protection, to some within a category as in McKinney, or excluding a particular area of discrimination as in Blaney, cannot provide the sole basis for determining whether a distinction has been drawn by the legislation. This case, too, is one of partial protection, although the exclusion or limit on protection takes a different form from that presented in McKinney and Blaney. Protection from discrimination is provided by the government by means of the IRPA, but only to some groups. If the mere silence of the legislation was enough to remove it from Section 15 sub 1, scrutiny, then any legislature could easily avoid the objects of Section 15 sub 1, simply by drafting laws which omitted reference to excluded groups. Such an approach would ignore the recognition that this court has given to the principle that discrimination can arise from under-inclusive legislation. This principle was expressed with great clarity by Chief Justice Dixon in Brooks and Canada Safeway Limited. There he stated under-inclusion may be simply a backhanded way of permitting discrimination. It is clear that the IRPA, by reason of its under-inclusiveness, does create a distinction. The distinction is simultaneously drawn along two different lines. The first is the distinction between homosexuals on one hand and other disadvantaged groups which are protected under the Act on the other. Gays and lesbians do not have formal equality with reference to other protected groups, since those other groups are explicitly included and they are not. The second distinction, and I think the more fundamental one, is between homosexuals and heterosexuals. This distinction may be more difficult to see because there is, on the surface, a measure of formal equality. Gay or lesbian individuals have the same access as heterosexual individuals to the protection of the IRPA in the sense that they could complain to the Commission about an incident of discrimination on the basis of any of the other grounds currently included. However, the exclusion of the grounds of sexual orientation, considered in the context of the social reality of discrimination against gays and lesbians, clearly has a disproportionate impact on them as opposed to heterosexuals. Therefore, the IRPA in its under-inclusive state denies substantive equality to the former group. This was well expressed by W.N. Rank in Case Comment, Vriend in Alberta, Discrimination, Burdens of Proofs, and Judicial Notice. If both heterosexuals and homosexuals equally suffered discrimination on the basis of sexual orientation, neither might complain of unfairness if the IRPA extended no remedies for discrimination on the basis of sexual orientation. A person belonging to one group would be treated like a person belonging to the other. Where, though, discrimination is visited virtually exclusively against persons with one type of sexual orientation, an absence of legislative remedies for discrimination based on sexual orientation has a differential impact. The absence of remedies has no real impact on heterosexuals since they have no complaints to make concerning sexual orientation discrimination. The absence of remedies has a real impact on homosexuals since they are the persons discriminated against on the basis of sexual orientation. Furthermore, a heterosexual has recourse to all the currently available heads of discrimination should a complaint be necessary. A homosexual, it is true, may also have recourse to those heads of discrimination, but the only type of discrimination he or she may suffer may be sexual orientation discrimination. He or she would have no remedy for this type of discrimination. Seen in this way, the IRPA does distinguish between homosexuals and heterosexuals. See also Poitier, it is also possible that a heterosexual individual could be discriminated against on the ground of sexual orientation. Yet this is far less likely to occur than discrimination against a homosexual or lesbian on that same ground. It thus is apparent that there is a clear distinction created by the disproportionate impact which arises from the exclusion of the ground from the IRPA. This case is similar in some respects to the recent case of Eldridge. There, the charter requirement of substantive, not merely formal, equality was unanimously affirmed. It was as well recognized that substantive equality may be violated by a legislative omission. The principle was explained in this way. The only question in this case, then, is whether the appellants have been afforded equal benefit of the law without discrimination within the meaning of Section 15 sub 1 of the Charter. On its face, the Medicare system in British Columbia applies equally to the deaf and hearing populations. It does not make an explicit distinction based on disability by singling out deaf persons for different treatment. Both deaf and hearing persons are entitled to receive certain medical services free of charge. The appellants nevertheless contend that the lack of funding for sign language interpreters renders them unable to benefit from this legislation to the same extent as hearing persons. Their claim, in other words, is one of adverse effects discrimination. This court has consistently held that Section 15 sub 1 of the Charter protects against this type of discrimination. Section 15 sub 1, the court held in Andrews, was intended to ensure a measure of substantive, not merely formal equality. Finally, the respondents' contention that the distinction is not created by law, but rather exists independently of the IRPA in society, cannot be accepted. It is of course true that discrimination against gays and lesbians exists in society. The reality of this cruel and unfortunate discrimination was recognized in Egan. Indeed, it provides the context in which the legislative distinction challenged in this case must be analyzed. The reality of society's discrimination against lesbians and gay men demonstrates that there is a distinction drawn in the IRPA which denies these groups equal protection of the law by excluding lesbians and gay men from its protection, the very protection they so urgently need because of the existence of discrimination against them in society. It is not necessary to find that the legislation creates the discrimination existing in society in order to determine that it creates a potentially discriminatory distinction. Although the respondents tried to distinguish this case from Bliss and Attorney General of Canada, the reasoning they put forward is very much reminiscent of the approach taken in that case. There it was held that a longer qualifying period for unemployment benefits related to pregnancy was not discriminatory because it applied to all pregnant individuals, and that if this category happened only to include women, that was a distinction created by nature, not by law. This reasoning has since been emphatically rejected. Eldridge also emphatically rejected an argument that under-inclusive legislation did not discriminate because the inequality existed independently of the benefit provided by the state. The omission of sexual orientation as a protected ground in the IRPA creates a distinction on the basis of sexual orientation. The silence of the IRPA with respect to discrimination on the ground of sexual orientation is not neutral. Gay men and lesbians are treated differently from other disadvantaged groups and from heterosexuals. They, unlike gays and lesbians, receive protection from discrimination on the grounds that are likely to be relevant to them: denial of equal benefit and protection of the law. It is apparent that the omission from the IRPA creates a distinction. That distinction results in a denial of the equal benefit and equal protection of the law. It is the exclusion of sexual orientation from the list of grounds in the IRPA which denies lesbians and gay men the protection and benefit of the Act in two important ways. They are excluded from the government's statement of policy against discrimination, and they are also denied access to the remedial procedures established by the Act. Therefore, the IRPA, by its omission or under-inclusiveness, denies gays and lesbians the equal benefit and protection of the law on the basis of a personal characteristic, namely sexual orientation. The denial of equal benefit and equal protection constitutes discrimination contrary to Section 15 sub 1. In EGAN, it was said that there are two aspects which are relevant in determining whether the distinction created by the law constitutes discrimination. First, whether the equality right was denied on the basis of a personal characteristic which is either enumerated in Section 15 sub 1 or which is analogous to those enumerated. Second, whether that distinction has the effect on the claimant of imposing a burden, obligation, or disadvantage not imposed upon others, or of withholding or limiting access to benefits or advantages which are available to others. A discriminatory distinction was also described as one which is capable of either promoting or perpetuating the view that the individual adversely affected by this distinction is less capable or less worthy of recognition or value as a human being or as a member of Canadian society, equally deserving of concern, respect, and consideration. It may as well be appropriate to consider whether the unequal treatment is based on the stereotypical application of presumed group or personal characteristics. The equality right is denied on the basis of a personal characteristic which is analogous to those enumerated in Section 15 sub 1. In EGAN, it was held on the basis of historical, social, political, and economic disadvantages suffered by homosexuals and the emerging consensus among legislatures, as well as the previous judicial decisions, that sexual orientation is a ground analogous to those listed in Section 15 sub 1. Sexual orientation is a deeply personal characteristic that is either unchangeable or changeable only at unacceptable personal costs. It is analogous to the other personal characteristics enumerated in Section 15 sub 1, and therefore this step of the test is satisfied. It has been noted, for example, by Justice Iacobucci in Benner that where the denial is based on a ground expressly enumerated in Section 15 sub 1, or one analogous to them, it will generally be found to be discriminatory, although there may of course be exceptions. It could therefore be assumed that a denial of the equal protection and benefit of the law on the basis of the analogous ground of sexual orientation is discriminatory. Yet in this case, there are other factors present which support this conclusion. The distinction has the effect of imposing a burden or disadvantage not imposed on others and withholds benefits or advantages which are available to others. Discriminatory purpose. It was submitted by the appellants and several of the interveners that the purpose of the Alberta government in excluding sexual orientation was itself discriminatory. The appellants suggest that the purpose behind the deliberate choice of the government not to include sexual orientation as a protected ground is to deny that homosexuals are or were disadvantaged by discrimination, or alternatively, to deny that homosexuals are worthy of protection against that discrimination. This, they contend, is a discriminatory purpose. The respondents, on the other hand, argue that there is insufficient evidence of a deliberate discriminatory intent on the part of the government. It is, however, unnecessary to decide whether there is evidence of a discriminatory purpose on the part of the provincial government. It is well established that a finding of discrimination does not depend on an invidious discriminatory intent. Even unintentional discrimination may violate the Charter. In any Charter case, either an unconstitutional purpose or an unconstitutional effect is sufficient to invalidate the challenged legislation. Therefore, a finding of a discriminatory purpose in this case would merely provide another ground for the conclusion that the law is discriminatory, but is not necessary for that conclusion. In this case, the discriminatory effects of the legislation are sufficient in themselves to establish that there is discrimination in this case. Discriminatory effect of the exclusion. The effect of the exclusion of sexual orientation from the protected grounds listed in the IRPA must be understood in the context of the nature and purpose of the legislation. The IRPA is a broad, comprehensive scheme for the protection of individuals from discrimination in the private sector. The preamble of the IRPA sets out the purposes and principles underlying the legislation in this manner. Whereas recognition of the inherent dignity and the equal and inalienable rights of all persons is the foundation of freedom, justice, and peace in the world, and whereas it is recognized in Alberta as a fundamental principle and as a matter of public policy that all persons are equal in dignity and rights without regard to race, religious beliefs, color, gender, physical disability, mental disability, age, ancestry, or place of origin, and whereas it is fitting that this principle be affirmed by the legislature of Alberta in an enactment whereby those rights of the individual may be protected. The commendable goal of the legislation, then, is to affirm and give effect to the principle that all persons are equal in dignity and rights. It prohibits discrimination in a number of areas and with respect to an increasingly expansive list of grounds. The comprehensive nature of the Act must be taken into account in considering the effect of excluding one ground from its protection. It is not as if the legislature had merely chosen to deal with one type of discrimination. In such a case, it might be permissible to target only that specific type of discrimination and not another. This is, I believe, the type of case to which Justice Lerendibé was referring in the comments she made in Obiter in her dissenting reasons in McKinney, where she said, "In my view, if the provinces chose to enact human rights legislation which only prohibited discrimination on the basis of sex and not age, this legislation could not be held to violate the Charter." Justice McClung in the Alberta Court of Appeal was of the opinion that these comments were binding on the court and compelled the allowance of the appeal. With respect, I believe he was mistaken. Those comments contemplated a type of legislation different from that at issue in this case, namely, legislation which seeks to address one specific problem or type of discrimination. The case at bar presents a very different situation. It is concerned with legislation that purports to provide comprehensive protection from discrimination for all individuals in Alberta. The selective exclusion of one group from that comprehensive protection therefore has a very different effect. The first and most obvious effect of the exclusion of sexual orientation is that lesbians or gay men who experience discrimination on the basis of their sexual orientation are denied recourse to the mechanisms set up by the IRPA to make a formal complaint of discrimination and seek a legal remedy. Thus, the Alberta Human Rights Commission could not hear Vriend's complaint and cannot consider a complaint or take any action on behalf of any person who has suffered discrimination on the ground of sexual orientation. The denial of access to remedial procedures for discrimination on the ground of sexual orientation must have dire and demeaning consequences for those affected. The result is exacerbated both because the option of a civil remedy for discrimination is precluded and by the lack of success that lesbian women and gay men have had in attempting to obtain a remedy for discrimination on the ground of sexual orientation by complaining on other grounds such as sex or marital status. Persons who are discriminated against on the ground of sexual orientation, unlike others protected by the Act, are left without effective legal recourse for the discrimination they have suffered. It may at first be difficult to recognize the significance of being excluded from the protection of human rights legislation. However, it imposes a heavy and disabling burden on those excluded. In Romer and Evans, the U.S. Supreme Court observed, "The exclusion imposes a special disability upon those persons alone. Homosexuals are forbidden the safeguards that others enjoy or may seek without constraint." These are protections taken for granted by most people either because they already have them or do not need them. These are protections against exclusion from an almost limitless number of transactions and endeavors that constitute ordinary civic life in a free society. While that case concerned an explicit exclusion and prohibition of protection from discrimination, the effect produced by the legislation in this case is similar. The denial by legislative omission of protection to individuals who may well be in need of it is just as serious and the consequences just as grave as that resulting from explicit exclusion. Apart from the immediate effect of the denial of recourse in cases of discrimination, there are other effects which, while perhaps less obvious, are at least as harmful. In Hague, the Ontario Court of Appeal based its finding of discrimination on both the failure to provide an avenue for redress for prejudicial treatment of homosexual members of society and the possible inference from the omission that such treatment is acceptable. It can be reasonably inferred that the absence of any legal recourse for discrimination on the ground of sexual orientation perpetuates and even encourages that kind of discrimination. The respondents contend that it cannot be assumed that the silence of the IRPA reinforces or perpetuates discrimination, since governments cannot legislate attitudes. However, this argument seems disingenuous in light of the stated purpose of the IRPA to prevent discrimination. It cannot be claimed that human rights legislation will help to protect individuals from discrimination and at the same time contend that an exclusion from the legislation will have no effect. However, let us assume, contrary to all reasonable inferences, that exclusion from the IRPA's protection does not actually contribute to a greater incidence of discrimination on the excluded ground. Nonetheless, that exclusion, deliberately chosen in the face of clear findings that discrimination on the ground of sexual orientation does exist in society, sends a strong and sinister message. The very fact that sexual orientation is excluded from the IRPA, which is the government's primary statement of policy against discrimination, certainly suggests that discrimination on the ground of sexual orientation is not as serious or as deserving of condemnation as other forms of discrimination. It could well be said that it is tantamount to condoning or even encouraging discrimination against lesbians and gay men. Thus, this exclusion clearly gives rise to an effect which constitutes discrimination. The exclusion sends a message to all Albertans that it is permissible and perhaps even acceptable to discriminate against individuals on the basis of their sexual orientation. The effect of that message on gays and lesbians is one whose significance cannot be underestimated. As a practical matter, it tells them that they have no protection from discrimination on the basis of their sexual orientation. Deprived of any legal redress, they must accept and live in constant fear of discrimination. These are burdens which are not imposed on heterosexuals. Perhaps most important is the psychological harm which may ensue from this state of affairs. Fear of discrimination will logically lead to the concealment of true identity, and this must be harmful to personal confidence and self-esteem. Compounding that effect is the implicit message conveyed by the exclusion that gays and lesbians, unlike other individuals, are not worthy of protection. This is clearly an example of the distinction which demeans the individual and strengthens and perpetuates the view that gays and lesbians are less worthy of protection as individuals in Canadian society. The potential harm to the dignity and perceived worth of gay and lesbian individuals constitutes a particularly cruel form of discrimination. Even if the discrimination is experienced at the hands of private individuals, it is the state that denies protection from the discrimination. Thus, the adverse effects are particularly invidious. This was recognized in the following statement from Egan. The law confers a significant benefit by providing state recognition of legitimacy of a particular status. The denial of that recognition may have a serious detrimental effect upon the sense of self-worth and dignity of members of a group because it stigmatizes them. Such legislation would clearly infringe Section 15 sub 1 because its provisions would indicate that the excluded groups were inferior and less deserving of benefits. This reasoning applies a fortiori in a case such as this, where the denial of recognition involves something as fundamental as the right to be free from discrimination. In excluding sexual orientation from the IRPA's protection, the government has, in effect, stated that all persons are equal in dignity and rights except gay men and lesbians. Such a message, even if it is only implicit, must offend Section 15 sub 1, the section of the Charter more than any other which recognizes and cherishes the innate human dignity of every individual. This effect, together with the denial to individuals of any effective legal recourse in the event they are discriminated against on the ground of sexual orientation, amount to a sufficient basis on which to conclude that the distinction created by the exclusion from the IRPA constitutes discrimination. The mirror argument. The respondents take the position that if the appellants are successful, the result will be that human rights legislation will always have to mirror the Charter by including all of the enumerated and analogous grounds of the Charter. This would have the undesirable result of unduly constraining legislative choice and allowing the Charter to indirectly regulate private conduct, which should be left to legislatures. It is true that if the appellant's position is accepted, the result might be that the omission of one of the enumerated or analogous grounds from key provisions in comprehensive human rights legislation would always be vulnerable to constitutional challenge. It is not necessary to deal with the question, since it is simply not true that human rights legislation will be forced to mirror the Charter in all cases. By virtue of Section 52 of the Constitution Act 1982, the Charter is part of the supreme law of Canada, and so human rights legislation, like all other legislation in Canada, must conform to its requirements. However, the notion of mirroring is too simplistic. Whether an omission is unconstitutional must be assessed in each case, taking into account the nature of the exclusion, the type of legislation, and the context in which it was enacted. The determination of whether a particular exclusion complies with Section 15 of the Charter would not be made through the mechanical application of any mirroring principle, but rather, as in all other cases, by determining whether the exclusion was proven to be discriminatory in its specific context, and whether the discrimination could be justified under Section 1. If a provincial legislature chooses to take legislative measures which do not include all of the enumerated and analogous grounds of the Charter, deference may be shown to this choice so long as the tests for justification under Section 1, including rational connection, are satisfied. Conclusion regarding Section 15. In summary, this court has no choice but to conclude that the IRPA, by reason of the omission of sexual orientation as a protected ground, clearly violates Section 15 of the Charter. The IRPA, in its under-inclusive state, creates a distinction which results in the denial of the equal benefit and protection of the law on the basis of sexual orientation, a personal characteristic which has been found to be analogous to the grounds enumerated in Section 15. This, in itself, would be sufficient to conclude that discrimination is present and therefore is a violation of Section 15. The serious discriminatory effects of the exclusion of sexual orientation from the Act reinforces this conclusion. As a result, it is clear that the IRPA, as it stands, violates the equality rights of the appellant Vriend and of other gays and lesbians. It is therefore necessary to determine whether this violation can be justified under Section 1. This analysis will be undertaken by my colleague.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.